The recent detention of the Ugandan opposition leader Dr. Kizza has sparked widespread concern. Besigye, a former presidential candidate, was arrested in Kenya and is now still facing a military trial in Uganda on charges of soliciting logistical support and identifying the military targets. Human rights defenders and other activists have called for the Besigye's immediate release, citing the misuse of the military courts to persecute civilians, particularly opposition supporters. This practice was condemned by the Constitutional Court of Uganda in 2021, and yet it continues to persist.
Where the Supreme Court nullified all orders of military courts regarding civilians, including Dr. Besigye and Obeid on Friday, meaning that even them spending a weekend in prison was wrong. But to make matters worse, the detention orders for Dr. Besigye and Obeid expired this morning. So any hours from today that these two spend in prison, General Byabashinja is likely to be held in contempt of court. He has no capacity to keep holding people. One, without detention orders. Two, for the authority of an expired entity like General Court-Martial.
This follows the landmark decision by the Supreme Court Judge Owenyi Doro, which resulted in the suspension of all cases involving civilians in the military courts. However, no response has been seen from the authorities so far.
Or ongoing criminal trials or pending trials before the courts-martial involving civilians must immediately cease and be transferred. Order. I'm going to chase you out. So I said all charges or ongoing criminal trials or pending trials before the courts-martial involving civilians must immediately cease and be transferred to the ordinary courts of law with competent jurisdiction.
They should be set free. The orders of court were that running cases should be transferred to civilian courts. So Besigye today should be produced either at Buganda Road, Chief Magistrate Court, or Nakawa, Chief Magistrate Court, or High Court, depending on where the Director of Public Prosecution has preferred to present them. But from today onwards, they need a new instrument to keep Dr. Besigye and Haj Obeid in prison or leave them to go home.
Additionally, Sarah emphasized that the military courts were instituted as a disciplinary tribunals for the members of the armed forces and that the restriction should not extend to the civilian cases.
Military courts are also supposed to be used more often when you have a situation of war where you don't have time to take a person to court and you need to quickly dispense that charge and continue with the fight. So in situations of stability like Uganda has been, even soldiers should not be tried in court-martial. But the court ruled that court-martial should be limited to serving soldiers, but also service offenses. So when a serving soldier commits a crime that is outside the service offense, he should be tried in civilian courts for those offenses.